I see that you have a lawyer. I don't know where they are, but we need to get cooking. So, okay. So, Mr. Mallard, you're charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 11:08 p.m., the officer was dispatched to a 911 call regarding a vehicle stopped on the road with the male in the driver's seat passed out on North 8th Street in Harris County, Texas. The officer observed the defendant's vehicle stopped on the road facing the wrong side, forcing multiple vehicles to drive around the defendant's vehicle. The officer observed the defendant's vehicle's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out. The vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat, and the officer attempted several times to wake the defendant unsuccessfully, which led to the officer being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the vehicle into park, and the defendant was asked to step out, who immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused any standard field sobriety test, and the defendant advised he had not consumed any alcoholic beverages, wished to speak to his lawyer, and was loudly repeating no consent to all questions. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed. The defendant was transported to HCA Southeast ER to obtain blood, and the defendant refused to exit the officer's motor vehicle, even when the officer asked multiple times. The officer had to physically guide the defendant out of the vehicle, and the defendant stopped walking while walking to the ER with the officer and advised he wanted to go to the Veterans Hospital. The officer advised the defendant he had a search warrant, and the defendant refused to move. The officer grasped the defendant's upper arm and advised the defendant again of the search warrant, and the defendant refused to move. The officer advised the defendant that if he had to pull him inside, he was facing additional charges. The defendant again refused to move. The defendant advised he wanted to go to the VA hospital, and the defendant started pulling away in the direction away from the entrance to the hospital. The officer attempted to pull the defendant to the entrance, and the defendant continued to pull away. The defendant went dead weight and laid down on the ground outside and refused to move while screaming on the top of his lungs, "Someone help me." The officer was assisted by hospital security in placing the defendant in a wheelchair, allowing transport into the hospital, and the defendant's blood was only able to be drawn with assistance of 3 officers holding the defendant down.
My goodness. Can you run his NCIC? Does he also have a felony DWI with the child as well?
It was reduced to a DWI just above a 0.15.
If you have a problem with alcohol, you better address it, Mr. Mallard, because if you don't, I'm going to do it for you. I don't want you out in the middle of the night, and I'm now giving you a curfew. You are not allowed out past 9 p.m. to 6 a.m., and I'm going to put a monitor on your ankle so I know that you're not out in the middle of the night. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. Likewise, I don't want you to drive. I am now taking away your privilege to drive as well. You are not allowed to drive. Do you understand?
Judge 96?
Yeah.
Raise your hand. Raise your hand.
Heed this warning. If I find that you drive, I can have a contempt hearing. Every single time that you drive, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand? I don't care what the justification is. Jesus comes, needs a right to church. I don't care. Do not lie. I am also now placing a restriction on your license that you
Excellent. That's all. Look, I couldn't see him.
I'm now placing an additional restriction on your license as well, that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle, number one, we're going to have issues with this. Number two, I'm sending now notice to DPS in Austin so that they know any vehicle that you drive is supposed to have an interlock in it. So if you're caught driving a vehicle that doesn't have an interlock, they will take you directly to jail. Do you understand? At this time, you're not allowed to drive. So you will get, well, you got the scram, so I'm not going to give you a portable device, but I don't want you drinking at all. This thing is extremely finicky that they're putting on your ankle. So know what you put in your body. Do you understand, Mr. Mallard?
Yes, sir.
If I find that you consume alcohol, anything that has alcohol in it, cakes, candies, foods, gums, energy drinks, hair dye, I've heard it all. If I find that you're consuming, it's really not going to go well. So I'm going to have you come up here, swear to this. After that, I'm going to get you to Ramona, where we will have you sign a reset. I will have you get with Felicia for your bond conditions, and then we'll have you take a seat while we wait for your guys to get here. Mr. Weber, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or a household member. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Just so you know, I appointed you a lawyer yesterday. Your lawyer is here with you now. He is on Zoom. We're going to do probable cause now.
Yes, Judge.
Judge, I don't know if you remember, we did probable cause yesterday. You found probable cause, unless you want to revisit it.
I do, because I don't remember anything about it. And I want to be
Yes.
able to hear it with him so that we're all on the same page. Just real quick, if you don't mind.
No.
Okay.
Yes, Judge.
Please.
On March 4th, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with the complainant and the defendant, who both stated that an assault did not occur. The officer then met with a witness who stated that he observed the defendant swing at the complainant 3 to 4 times. The officer spoke with a second witness who stated that the defendant opened the passenger door and punched the complainant 5 times. And when the complainant got out of the car, observed the defendant strike the first witness in the torso and shoulders. The officer then spoke with a third witness who stated that he saw the defendant strike the complainant 3 to 4 times with a closed fist and heard the defendant state he would fuck you up to the complainant.
Mr. Weber, I don't want you to have any contact with this person. Do you understand me?
And Your Honor, if I may, after having contact with the complainant and Sebastian for me as well, we would be okay with no threatening and harassing.
No,
Yes, Judge.
no. I don't want you to have any contact with this person. And I want you to understand now that I'm going to protect every person in my county, regardless of who they are, what color they are, they're a small farm animal. Do you understand? Don't have contact with this person. If I find that you violate these conditions, if I find that you become a danger to my city, if I find that you pick up a new case, I'm going to revoke these bonds and I will make them high. Do you understand?
Judge, if I may.
Please.
Judge, the CW was the one that came into court yesterday. She's a clerk for the Harris County District. She's a clerk there in Harris County.
Say it again.
She's a clerk there in Harris County.
The complaining witness is a clerk here in Harris County?
Yes, Judge.
Okay,
She's
So-
the one that gave us those affidavits yesterday that you showed me.
I understand, but
she-
I've got, go ahead. Go ahead.
She did not have any visible injuries. She states to me and to the district attorney that they were fighting over the keys and that it was just that it was mutual and that no injury occurred. She did not have any bruising again. She told that to the officer when she was arrested. Oh, I'm sorry, when my client was arrested. There were no visible injuries, nothing that would corroborate what the witnesses are saying.
There
Now,
are 3 different independent, unrelated witnesses who see first 4 to 5 punches in the head. And then as he allegedly takes her out of the car, these same witnesses see 3 to 4 punches in the stomach as well.
again, Judge, if that were the case, we'd have some injury, Judge. We don't have any injuries that are noted by the police in the report or by the CW when I saw her yesterday or the prosecutor when he spoke to her yesterday, Judge.
Judge, just to confirm, yes, that's what the complaint told us as well. The same thing. There were no visible injuries, no bruising, and that's why I'm asking you, we'd be fine with the threatening harassment.
Come up, ma'am. I want to make sure that every single person here is protected, you know, and 99.9% of the time, I always like to follow what the complaining witness is, meaning you, what your wishes are. Because, you know, I really take that into account. I have to be honest that from what the witnesses' statements say, it sounds really, really just aggravating and just, I don't want you to say anything. And so when I see something of this nature, it really takes me back. And that's why, you know, there's a method to my madness and why I do what I do, and to, you know, to protect you, because I don't want something to happen to you. That's because you're the person I care about. What would you like?
I have those affidavits in my prosecution. For a reason, I didn't call the police. I don't know what they saw.
I don't want to talk about the case. I just want to know do you want to have contact with this person?
Yes. We deal with a lot of things together. We didn't hurt things, so I don't know.
There is an order for protection that is in place now. I don't give a rat's behind what is going on. I don't care what stressors you have in your life. But if I find that you put hands on anyone, I'm going to put my hands all over your bonds and I'm going to rip it. Do you understand? I don't care what is going on in your life. You put hands.
Okay.
It's really not going to go well. Number one. Number two, the court order that I have now, the order for protection, says that you're not to have any threatening or harassing contact with the complaining witness. I don't care what you think is threatening or harassing. It's what she perceives. So can conduct in and of itself violate this thing? If I go like this, is that threatening or harassing? It is, and it will land you in jail. Do you understand? I will do what you wish, but if I find anything happens in the future that hands are put, threats are made, I'm going to yank the bonds and that's it. Okay. So if you guys want to do a rip now, I don't know if you've already done it.
We've already,
But okay.
It's fun, Judge.
So do you mind filing a threatening,
Oh.
harassing, no weapons? You're not to be in possession of weapons as well. Do you understand? Okay. Take a seat for me while we get everything ready for you, sir.
He said.